Thank you, Presiding Officer. I open this debate with thanks to the Criminal Justice Committee for their Stage 1 report on the Victims' Witness and Justice Reform Bill. It represents comprehensive scrutiny over many months of an important bill which aims to improve the experience of victims whilst protecting the rights of the accused. I welcome that the committee took evidence from victims and survivors and did so in a way which supported them to tell their story and be part of improving the justice system. And I thank everyone who gave evidence to the committee, but I give particular mention to the victims and survivors who, quite rightly, are at the centre of the bill and the process of reform. Presiding Officer, I want to reflect on why this bill is needed. Scotland's justice system has evolved over centuries. Similarly, our definitions of what is criminal behaviour has changed over the years, reflecting changes in societal attitudes. These two elements go hand in hand. Our system must be capable of delivering justice for victims of all crimes and of adapting where it is not serving us well. No part of our justice system should be exempt from scrutiny. While there have been positive, iterative reforms over the years, the committee has heard compelling evidence that for many the process of justice is just as traumatic as the crime itself, or where a case results in a verdict which has no definition and cannot be explained to the victim or the accused, it can feel like there has been no justice. That is simply not good enough. The bill proposes a package of reforms which responds to the views and concerns shared by victims and survivors. It is informed by the work of the Victims Task Force, Lady Dorian's review into improving the management of sexual offence cases, and by independent large-scale jury research. We want to deliver a system where victims are treated with compassion and their voices are heard, which meets the needs of survivors of sexual offences, the majority of whom are women and girls, and which is a more modern and transparent at enhancing public confidence. Presiding Officer, I am pleased that the Criminal Justice Committee supports the general principles of this bill. I welcome the committee's recognition of justice agencies' commitment to trauma-informed practice, alongside an acknowledgement that more needs to be done to embed this across the system. The bill creates a statutory definition of trauma-informed practice and introduces a requirement for justice agencies to set standards for and report on trauma-informed practice. The bill will strengthen ongoing non-legislative work, including the Knowledge and Skills Framework, which was introduced last year. The committee heard from many witnesses that legislation is key in this regard. As Lady Dorian said, it will provide the impetus towards creating the necessary culture change. The bill also recognises that civil proceedings can also cause trauma. It enhances protection for vulnerable parties and witnesses in civil cases by extending the use of special measures and by protecting people who have suffered abuse from being cross-examined by their abuser. The bill seeks to reduce trauma and improve experiences through the creation of 2 new automatic rights for victims of sexual crime. The right to anonymity for victims of sexual and certain other offences is particularly important in today's social media age. It will help protect victims' privacy and dignity and may increase the confidence of victims to report offending. The publicly funded right to independent legal representation for complainers when requests are made to lead evidence about their sexual history or character is a substantial change to a deeply intrusive aspect of sexual offence cases. It will mean that a complainer is recognised as a party in the proceedings in respect of such applications, helping to ensure they understand the process and that their voice is heard. Presiding Officer, I very much welcome the committee's view that the not proven verdict has had its day. It is a verdict that is not defined or well understood, and which can lead to confusion and trauma for victims and stigma for the accused. The bill will abolish not proven in all criminal cases and retain the widely understood verdicts of guilty and not guilty. Now, I recognise that the bill raises challenging issues and that some proposals were not supported by the committee. And this includes the jury reforms that accompany the removal of the not proven verdict. The bill proposes to reduce the number of jurors in a criminal trial from 15 to 12 and change the size of the majority required for a conviction from a simple majority to 2/3. The Scottish Government's position is based on the evidence that suggests that moving to 2 verdicts while retaining a simple majority will lead to an increase in convictions in finely balanced cases. No other similar jurisdiction in the world considers it appropriate for convictions to be based on a simple majority decision. The evidence also tells us that groups of 12 deliberate more effectively than groups of 15. However, Presiding Officer, we have always recognised that a range of experts have differing views on what reforms, if any, should accompany the abolition of the not proven verdict. And I respect that the committee came to a different conclusion than what is proposed in the bill, and I will think carefully about the issues that committee has raised.
Cabinet Secretary.
Presiding Officer, we will of course consider the debate in and around the jury majority with sensitivity, with depth. We will look at all the relevant issues and engage with all relevant stakeholders in this regard. This is an area of the bill that involves finely balanced judgments. We do need to proceed in a manner that we all work together but also give careful but deep consideration. And I do reiterate, one, the importance of this part of the bill, but also reiterate that the Government will indeed reflect in detail on the wide range of comments that committee has scrutinised. Presiding Officer, the proposed Victims and Witnesses Commissioner will provide an independent voice for victims and witnesses, champion their views and help ensure their interests are at the heart of the justice system. I note that committee's reservations, particularly around resource and the impact on victim support organisations. However, I believe this role can be established in a way that is cost efficient and can enhance the work of support organisations rather than diminish or duplicate their efforts. During the evidence sessions, lack of accountability was an issue that kept being raised. No existing public body or organisation has the statutory power to hold justice agencies to account in relation to how the rights of victims and witnesses are met or upheld. Nor can this role be given to a third sector organisation. The Commissioner will provide that accountability. Presiding Officer, I now turn to parts of the bill that focus on sexual offences and where there are mixed views. Both Lady Dorian and Lord Advocate emphasised that we need to make seismic, structural, statutory changes to ensure victims and survivors have meaningful access to justice. The bill does this through the creation of a new National Sexual Offences Court. Complainers' experiences will be improved through greater use of pre-recorded evidence, better judicial case management and mandatory trauma-informed training for all involved in the court. A new and distinct court will bring about the necessary shifts in culture, practice and procedure. Cases will be brought to trial more quickly through more efficient use of existing court and judicial resources, helping to reduce delay, which is a significant cause of distress and trauma for complainers. Victims cannot afford for us to rely on the historical status and structure of the existing court system to deliver changes that we all agree are needed and which the status quo has singularly failed to deliver. If we fail to take ambitious action now, we risk consigning victims to unnecessary re-traumatisation through a court system that is not sufficiently specialised and focused on improving victims' experiences. This is a risk, Presiding Officer, that I am not prepared to take. I recognise that committee has concerns about certain aspects of the court, and I will work very hard with members and justice partners to address each one. Presiding Officer, the bill enables a time-limited pilot of single-judge rape trials. The proposal for the pilot is informed by complainers' experiences of the trial process, by numerous studies on rape myths, and by the fact that conviction rate for rape is consistently lower than for other crimes. Soberingly, the new data based on management information from the Scottish Courts and Tribunal Service that we have included in our response to Stage 1 report shows that for the kind of cases the pilot is intended to focus on, namely single charge, single complainer rape and attempted rape cases, the 5-year average conviction rate is just 24%. The purpose of the pilot will provide much needed evidence to let us have a properly informed debate on an enduring issue that undermines confidence in our criminal justice system. Now, I acknowledge that there are differences of opinion on both the court and the pilot, and I have and will reflect on that, as I have already done in the response to committee, and have intimated that I will be bringing forward amendments at Stage 2, and I will speak more about that in my closing remarks, Presiding Officer. But it is clear that our justice system needs to change the way in which it responds to serious sexual offending. As legislators, it is our role to determine the legal frameworks that ought to be in place, and no part of our justice system should be exempt from review and, if necessary, reconsideration. Yes, Presiding Officer, I can give that clarification to Ms Graham, that the pilot, whatever form it takes, is to look at rape and attempted rape cases, and I've already given commitments to committee to put more detail around the criteria and the operation of the pilot on the face of the bill. Presiding Officer, this bill has been shaped by cross-sector consideration and collaboration, and I am absolutely committed to taking the same approach as it progresses through Parliament. And I will work constructively across the Chamber with our stakeholders and partners and with victims and survivors to deliver the transformational change that is required. And I am sure members will approach the bill in the same spirit that we have thus far debated and discussed within the committee process to what I believe has been the highest possible standard. Presiding Officer, I know that the issues dealt with by this bill are significant and complex. As parliamentarians, we are making decisions which will have far-reaching consequences. But I believe the case for change is clear. I believe that the time for change is now, and it is incumbent on us to work together to deliver the justice system that our society needs and deserves. Giving evidence to the committee, Lady Dorian said, if we do not seize the opportunity to create the culture change from the ground up, there is every risk that in 40 years my successor and your successors will be in this room having the same conversation. Presiding Officers, I will continue to work with members and invite them to work with me on this landmark bill, and I move the motion in my name. Thank you.